Good morning, good afternoon, and good evening, everyone. Welcome to PHR's online briefing, Next Steps for the Global Anti-Torture Movement, Istanbul Protocol 2022. Physicians for Human Rights has been at the forefront of the anti-torture movement, and I'm very happy to continue that tradition with this conversation today. As we get started, I'd like to share a story from my own experience to show you how important it is to understand what torture is and how we can support survivors. I'm an emergency physician, and a few years ago, I was working with a resident when he saw a patient with some foot pain. No recent trauma, really nothing but some old scars on his ankle. As usual, I saw the patient myself after he did, and he had a big scar that wrapped all around his entire ankle. And he had a matching one on the other ankle. Okay. I talked a bit more with the man. He was kind and easy to chat with, but not very forthcoming about really what happened. But after some time, we did get more history and we could help him. He was tortured for several years, some of them in solitary confinement, and was a political prisoner before escaping to the United States through an insane circuitous route. The ankle scars, they were from being hung upside down for hours at a time, days even. Now he was safely in California for a year, but he couldn't work a legal job because his asylum status was not complete. So he was working odd jobs that were exhausting him in bad shoes that caused his foot pain. Knowing his story, we were able to help him in a number of ways. We could find him some better shoes. We got him set up in the Human Rights Clinic for regular care, including mental health services. We were able to help him find a lawyer that could support his asylum case. And in the clinic, we did a forensic evaluation to support his asylum application. This is not a rare or a unique example. As a colleague of mine often says here in California, you can't find something that you're not even aware of. On that note, I'm excited to share with you a new tool to help you be aware of torture and of all the things you can do about it. The Istanbul Protocol was officially accepted as a UN document in 1999 and first published by the Office of the United States High Commissioner for Human Rights in 2001. For more than 20 years, it has been the global standard to investigate and document allegations of torture and ill treatment, and has just been updated after a mammoth 6-year effort by more than 180 torture experts across 51 countries. Today, we are joined by 5 of these experts who will discuss what torture is and how the new edition of the Istanbul Protocol can be used to prevent torture and hold perpetrators accountable. They will also outline next steps in global anti-torture efforts. The panelists are here today with a wide range of anti-torture experiences and expertise. We will listen in on what I'm sure will be a brilliant conversation between these friends and colleagues on their life work. We also welcome you to submit your questions for the panel via the Q&A function on Zoom. We'll get to as many audience questions as possible. I will try to moderate with military timing and a light hand. So let's begin. I'll start out with a question for Dr. Vince Iacopino, and I'll go with first names. Vince came up with the idea of the Istanbul Protocol and led the development of all editions of the IP, including the current one. He retired recently for more than 25 years at Physicians for Human Rights as the medical director. He's an international expert on anti-torture activities, among other things, testifying in trials about the torture in Guantanamo, and has implemented IP standards in many countries, really founding this work. So, Dr. Iacopino, can you start us off? What is torture, and why did you come up with the idea of having a manual on investigating and documenting torture in the first place?
Thanks, Rohini, and welcome everyone. Well, torture, I think, at least in the Istanbul Protocol, we refer to the definition in the UN Convention Against Torture, or CAT, as we abbreviate it. I'm going to cite that definition, but be aware that there are different definitions in various states, and there are distinctions between torture and its cousins, cruel, inhuman, and degrading treatment, which we shorthand as ill treatment. Basically, torture is any act where there is intentional infliction of severe physical and or mental pain that's committed by or with the acquiescence of state officials. And it lists some purposes, unfortunately, in my opinion, the purposes of gaining information, obtaining information, or punishment, or for any other reason based on any form of discrimination. I will translate that into my understanding, which is violence to achieve some end by state officials. The Istanbul Protocol, the new edition, actually talks about this definition and the distinctions between CIDT, cruel, inhuman, and degrading treatment or punishment, and torture, and also talks about the scope of torture. For example, it's not always in custody in the traditional way that you may think, where it takes place. The severe infliction of physical or mental pain can take place extra-custodially. For example, in the context of demonstrations, or as people in the United States know, the policy of forced separation of families on the border of the US and Mexico. So there are lots of examples in the new edition of the Istanbul Protocol of torture in its many different forms. To answer the question of how the idea came about, it was somewhat, innocent and remedial rather than conscious and deliberate process. Şebnem and I and several others were at a meeting in Adana, Turkey in 1996. It was a lunch break, and several colleagues, US colleagues, proposed a research idea, which I didn't think was a good idea or benefited our Turkish colleagues very much. And so I made a counter proposal to help our Turkish colleagues, because at that time, they were submitting outstanding evaluations of alleged torture in court cases, whereas the state forensic physicians were not doing the appropriate documentation and simply saying that there was no sign of injury or lesion. And so I had the idea that we would create a framework to empower our colleagues in civil society, and name it the Istanbul Protocol, by the way, and also to hold states accountable by having this framework of what evaluations should look like. That's how the idea came about. Everyone agreed around the table, and it took us 3 years to create the initial guidance in the Istanbul Protocol.
Thank you, Vin. Second, I'd like to bring in Juan Mendez. Professor Mendez is the former UN Special Rapporteur on Torture, a position he served in from 2010 to 2016. He's currently a professor of human rights law in residence at the American University, Washington College of Law. Professor Mendez, you started out as a young lawyer in Argentina. How did your experience in prisons there during the junta shape you? And how do you see the IP concretely helping people who have survived torture?
Well, thank you for your question, Rohini, and thanks PHR for the opportunity to share in this exciting webinar. Yes, in fact, I've been a lawyer now for more than 50 years, and in my first years of practice, I did a lot of criminal law, particularly defending political prisoners. So even before I was arrested myself, I was well aware of the cruelty and the brutality, but also the frequency with which torture was used in Argentina, especially against political prisoners, which were my clients, my defendants, but also with common crime offenders. And unfortunately, it's a practice that has not ended even after we recovered the democracy in 1983. So I found that litigating issues of torture was very difficult because of the attitude of courts and prosecutors of ignoring us when we complained that our client had been tortured. But it was assisted enormously with the information provided by an expert witness with medical or psychological training that at least made it possible for courts not to ignore us. So unfortunately, that doesn't mean that by the time I was tortured myself, I was prepared for it, because I don't think anybody can really prepare for the experience of torture. And I spent a year and a half in prison, and I was tortured to not so much to confess, because there was nothing that I could confess, but to reveal identities and names of my friends and colleagues. And but fortunately, because my family and my lawyer friends acted very quickly, the experience of torture was such that I didn't have in my conscience having revealed any information that would take somebody else to being tortured. But in terms of how that shaped my professional life, first I have to say that I have been very fortunate to be able to work as a lawyer in human rights for more than 50 years now. And I feel fortunate about it. And yes, most of my practice internationally, particularly when I left Argentina, has been centered around torture and ill treatment and enforced disappearances, for example, although I actually do work on other issues like freedom of expression, like fair trials and due process of law. But torture continues to be my I don't know if to call it a vocation or an obsession, but it is, and the opportunity of working with so many enlightened professionals like Vince and so many others, Şebnem and Juliet and James, was one of the highlights of those 50 years of my experience. So thank you very much.
Thanks, Juan. You mentioned the doctors that you worked with, so I'd like to ask from Şebnem Korur Fincanci first. She's the president of the Turkish Medical Association and a leading human rights activist and a forensic pathologist for more than 3 decades. So, Şebnem, it's called the Istanbul Protocol. So I wanted to ask you, why is it called the Istanbul Protocol? And how has the IP been used in Turkey?
Thanks a lot, Rohini, for the question. And we have to ask Vince, because he told that we have started everything in Adana. So maybe it should be Adana Protocol. But then, of course, the final documents have been just in a meeting in Istanbul. And the Forensic Medicine Department of Istanbul University hosted that meeting. So out of courtesy of our colleagues, they suggested to name this guideline as Istanbul Protocol. So it's an honor for us, because we all together have struggled a lot and had the support and solidarity of PHR for many years then. So it helped a lot, of course, Istanbul Protocol, because when you discuss torture and try to document these kind of cases, then you are the target of the states. And they just claim that you have bias with such kind of cases. And sometimes you are called terrorists. For example, I am one of the biggest terrorists of Turkey because of many torture survivors that I have examined and provided medical legal documentation. And every time the organization, the terrorist organization changes, because then one torture case is from a different political movement and the other from another political movement. So we use this document as an evidence. And we say that we work on evidence base and according to the guidelines of effective documentation of torture. So we have to have the narratives, all of these cases with narratives, and the physical and psychological evaluation help us to just put forward an evidence for torture. And in Turkey, in several cases, of course, we have provided medical legal reports, or in many cases, only the lawyer sometimes had the means to reach to the tortured survivor because the tortured survivor is imprisoned, so that only contact is the lawyer. So the lawyers can use these kind of documents, the body charts, and have the narrative of torture, so that we can afterwards discuss together with the health professionals how to build the medical legal evaluation at the end. So in many cases, we were just in the courts and tried in several court cases for being partial to the torture survivor, but the Istanbul Protocol, the guideline, helped us and supported our evidence-based reports, documentation, actually.
Thanks, Şebnem. So next, Juliet Cohen. Juliet is a physician specializing in the examination of victims of torture, domestic violence, and trafficking for servitude and prostitution. Juliet, you formerly served as the head of doctors at Freedom from Torture for over 15 years. What successes and challenges have you seen on torture and anti-torture work in your tenure?
Thank you, Rohini, and thanks for inviting me to this panel. So great to see everybody again. I think there've been quite a number of successes, which is really good to look back on. One of the main things that I think we've achieved is the adoption of these standards so that they're recognized by the courts in the UK, making asylum decisions in particular, and showing how using the Istanbul Protocol standards and seeing those reports, we can help decision makers to better understand the medical evidence that they have put in front of them. And going alongside of that and contributing has been using the Istanbul Protocol to train doctors to raise the quality of reports. I mean, when I first started in this work, which was in the late 90s, we were writing very short reports, 2, 3, 4 pages would be really long. And we were just describing the bare outline of what had happened and noting down a number of scars. There wasn't really a proper interpretation. There wasn't a comparison of other possible causes for how someone could come upon those injuries. And we really weren't doing any kind of psychological assessment. So the Istanbul Protocol really helped us to understand how to make a holistic assessment of all the findings that there might be to document and interpret the torture allegation. And I've also found it really useful to train doctors in how to help torture survivors talk about these unspeakable things, because it's so difficult for people to disclose everything that's happened. I always tell people, I think probably no one's ever told me everything. There's always something they probably held back, but we can help them to talk about what they do feel ready to disclose. And the better trained doctor will be better at doing that and be mindful of the risk of re-traumatization. And the Istanbul Protocol has a lot to say about that to help us. I think it's also been great to help decision makers better understand memory and recall issues. And so when they're making their assessment of credibility and they're looking at inconsistencies in the account, we can help them consider the impact of torture on a person's ability to recall and recount experiences and how their psychological condition may be affecting all sorts of aspects of their cognitive function, and then consider how that may contribute to inconsistencies. You asked about challenges as well, and one very important challenge, I think, in the UK was the case of KV, who was and is a Sri Lankan whose case went all the way to the Supreme Court in the UK. As an asylum seeker, this is very rare. Most cases are decided initially just by the Home Office or in the first tier of the tribunal. So to go all the way through to the upper tribunal, the Court of Appeal, the Supreme Court was a really exceptional situation. But what was critical for the Istanbul Protocol was that the lower court, the Court of Appeal and the upper tribunal had challenged the ability of the doctor, almost the right of the doctor, to make an assessment about how the injuries had come about. So what they were doing was saying the doctor can only say this is a burn or this is not a burn. And they were suggesting that the doctor can't make any comment about how that burn injury was sustained. And it was so important that we challenged that. And we used the Istanbul Protocol to do that. And I gave a statement, Vince gave a tremendous statement as well, because it was so critical. And what we managed to show was that the principles, not just of the Istanbul Protocol, but really the foundation of forensic medicine, it's very clear that the forensic doctor must give an opinion, not merely on the type of wound, whether it's a bruise or an incised wound or a burn, but they must give opinion also on the cause. And the guidance of the Istanbul Protocol is really crucial in assisting the expert to formulate that opinion, to demonstrate the steps by which they reach their conclusions. So yeah, that was a big challenge, and I'm pleased to say that we succeeded in that. Thanks,
Juliet. And finally, James Lynn. James is the Istanbul Protocol Program Coordinator at the International Rehabilitation Council for Torture Victims. James, as a lawyer, how has the Istanbul Protocol supported documentation and accountability for torture at international levels and at national levels?
Thanks so much, Rohini, and to PHR for holding this important webinar. It's great to see everyone. As we've heard, the Istanbul Protocol really provides an important framework for our work on investigating and documenting torture, and really just working with torture victims. And I think as your story that you began today with demonstrates, we are understanding more and more the need and the responsibility of greater sections or segments of society to understand torture, right? Medical doctors need to understand torture because they may see individuals or survivors in their regular practice. Lawyers have to understand. And so, you know, as we sort of broaden out, and then really as the human rights movement itself over the last several years really broadens out and changes, right? With the advent of technology, with the advent of greater social media and communication, right? Young people going to protests and coming prepared, right? You know, bringing materials, learning how they go to protest, to document, learning how they collect evidence. These kinds of frameworks become more and more important. And they really are, in some ways, as you I think heard from Şebnem and you know, Juliet and Juan's examples, they become a great equalizer. Because they provide you know, both specialists like ourselves, but as well as general professionals and even the regular public with a understanding of how to address issues that are important to society, how to address torture and ill treatment, both in terms of what torture is, like Vince mentioned, as well as you know, the impact of torture on individuals, the consequences, like Juliet mentioned, and ultimately even then how to document and how to carry these cases forwards. So I think it's very important in that way, and it really has, in some ways, served as a way to level up the experience and capacity of the public and civil society when we face these kinds of issues.
Thank you, James. And thank you all of the panelists. So I'd like to invite you to ask each other questions and follow up on answers as well. And for those in the audience, please feel free to submit questions for panelists through the conversation in the Q&A box at the bottom of your screen. We'll get to as many as we can at the end of the discussion. But I'll start off with a question for the group. What experiences can you share about how you use the IP? Juliet, you gave a really concrete example, and I thought that was really illustrative of how important and complicated it is to use the IP and what you do with it. So I'd invite anyone else who had thoughts about that to get started. Şebnem.
Thanks, Rohini. Yes, actually, a few examples will be important. One was a refugee case who was sent to our department for age estimation. And since we use Istanbul Protocol guideline for all the medical examinations for these kind of cases, after a detailed narrative, and of course, the thorough medical examination, we realized that he had some scar formations on the armpits. And of course, he had just related the suspension torture in his home country, unfortunately. So then, although he was underage and would just be eligible for protection, but then torture also prevented him from being sent back to his home country after 18. So it was very helpful, of course, not only the age estimation, but we have to just evaluate all the cases according to the guideline. Actually, Istanbul Protocol is not only a specific document, a guideline, but the explanation of how we practice on daily basis. So we have to use the Istanbul Protocol as a routine for such kind of cases. And another one is for our lawyer. One enforced disappearance for 6 months, just immediately appeared in a jail, and we didn't have any means to reach the case. But our lawyer visited, and the lawyer was trained on Istanbul Protocol. So she collected all the evidence, had the story, and just draw all the marks on the body on a body chart. And afterwards, we came together with a psychologist, discussed the case, and afterwards, when we provided the documents, then this helped a lot for her to be released afterwards. So this kind of examples are too many. And I have to remind that the guideline is not a specialization based document, but it can be used by everybody. As James had told, that the lawyers should know about that, the physicians should know about that, but the human rights activists also should know about that when they try to just raise their voice and demonstrate and being tortured, then they have to know how to collect the evidence. Thank you.
Thanks, Şebnem. And Vince?
Thank you. There are so many examples of how the Istanbul Protocol has been used over time in the past 20 plus years. And through my work at PHR, I've had the privilege of engaging in many of these activities, but I would also
You froze up there for a second. Does anyone else want to jump in while we get Vince back?
Yeah, I was going to say a couple more things. That some really key paragraphs that I use a lot in the Istanbul Protocol are setting out the important principles that even if there are no scars or very few scars, that cannot be taken to assume that the person has not been tortured. And even if there isn't a specific psychiatric diagnosis reached, again, that doesn't mean that the person hasn't been tortured or hasn't been impacted by torture. So those principles I've often cited, and I think the importance of these paragraphs to cite and to demonstrate to decision makers and others that it's not just my opinion, this is a collective wisdom of global experts, and it's been extensively peer reviewed, and there are many references to support these opinions. So that's been really helpful to our work.
Thanks, Juliet. Let me jump back to Vince.
Can you hear me now?
Yeah.
Wonderful. So there are many examples of how the Istanbul Protocol has been used. I would direct people to an article that you authored and I co-authored with you that we actually did before launching into the update on the Istanbul Protocol to find out how people were using it and what they thought about the appropriate updates, et cetera. Maybe we can share that article with people, the survey that we did. And clearly, as Şebnem and Juliet have already mentioned, in individual medical legal case settings, whether it's asylum or criminal cases and so forth, the Istanbul Protocol is extremely important in guiding clinicians to document the physical and psychological effects and to make the appropriate conclusion, as Juliet mentioned, now that the UK has sort of marching orders to do. And but also human rights investigations. When I've participated in investigations of torture, even population-based studies of human rights violations in war zones and so forth, we use the Istanbul Protocol as guidance to document that kind of treatment. And more recently in other settings, as I mentioned previously, in the setting of forced separation on the border of the US and Mexico, also in extra custodial settings such as crowd control, the use of lethal force, so-called less than lethal force, which is intentional and severe and has very harmful physical and psychological effects. So there are human rights investigations. Clearly, we want to build capacity in other countries for people to be able to document that. So we use the IP for training. And one of the new chapters in the Istanbul Protocol is on implementation. We've learned over the past 20 years that it's not enough just to have provided the initial guidance on how to conduct a legal or clinical investigation documentation of torture. To make it work in states where it's a challenge, it's necessary to provide the necessary conditions for effective investigation and documentation. And so we've developed guidance over a long period of time on how states and civil society can implement the Istanbul Protocol. So it really calls for a sea change across multiple sectors, the law enforcement, judicial, forensic, et cetera, all these different sectors in society and most importantly with civil society. So the capacity building and implementation is critical. I'll leave it at that right now.
Thanks, Vince. Juan, did I see you wanted to make a comment about that?
Yeah, but following on what Vince was saying, my experience obviously is with not doing examinations myself because I'm a lawyer, but I've been training public defenders and prosecutors and judges and court officials on how to prevent and how to detect torture. And I'm very certain that the new protocol is very helpful in the first place because it incorporates a practice of implementation and bad implementation that we have had for 20 years, but also it incorporates the advances of science. In 20 years, it has been enormous. And it incorporates the advancement of law because in international law, the standards in 20 years have evolved very significantly as well. And so when you find, for example, an examination made of 11 supposed torture victims in the same room at the same time and without letting them give a narrative, and then the doctor says that marks in the body are consistent with maneuvers of apprehension by the police, you can tell with the new Istanbul Protocol and with the old as well, I suppose, that that's not a protocol, I mean, an examination correctly done. And so you equip not only clinicians, but also lawyers, defense lawyers, but also court officials and prosecutors in critiquing the way examinations are done when they are done with a purpose of impunity rather than with a purpose of documentation.
So let me jump off of that. Many folks have been using the Istanbul Protocol since 1999 when it was first introduced. Now we have the new one published in June. And why did it need an update? And really, what has changed in this document that folks need to know about? And maybe, James, I'll start with you on that one.
Thanks, Rohini. Well, as you mentioned, it's been 20 years, right? And as we know, our understanding of torture, both what it is legally, but as well as then its effects and its consequences have changed so dramatically over this time period. So it really needed an update in this kind of way. As well, really our practice of documenting torture, right? At the IRCT, we are a network of rehabilitation centers across the world in 75 countries. And the way that we approach torture, our understanding of how to treat victims, our understanding of how certain acts impact them has also evolved greatly as we work more and more with victims of torture. And so all of this, understanding, all of these lessons learned, we say, has been sort of put into this document. And it also became clear through, as Vince has mentioned, this 20 years of implementation, that there were certain challenges. In many ways, I think everyone who has seen the new protocol, it's much longer. But it's much longer because there's so much more guidance in it, right? And we were asked to really provide much more guidance on how to conduct an appropriate interview, right? As Juan mentioned, and Juan has done an excellent job of, there was so much more guidance on really what torture means, right? What kinds of acts and what kind of behaviors should quantify as torture, not just what we consider to be traditional acts. So all of this has gone in, and even in the new chapters on how we implement, right? Because the Istanbul Protocol is both a manual for practitioners, human rights, lawyers, professionals, but it's also serves as a policy document in many ways for us to then say, this is the medical consent. This is the consensus globally from experts on what torture means, right? And how we have to approach it from a policy, legal practitioner standpoint. So sorry, it's gotten longer.
Vin?
I'd like to add to what James just said and reassure people that what we're referring to as the new edition of the Istanbul Protocol is not a new protocol. It's not, we had strict criteria only to strengthen and improve and to clarify and update the original Istanbul Protocol. So the principles, the Annex 1, that's just a page and a half, that has not been changed. The Annex 4, which is the outline of how to conduct a clinical evaluation, it has not changed. The strengthening process has to deal with what others have already said. For example, in the legal sections, Juan knows well, we've updated the definition of torture as we understand it. We've provided the current jurisprudence on torture, prevention, accountability measures, etc., and investigations, the current procedures, and spoken directly to judges who are critical targets of the Istanbul Protocol and making just decisions about torture. But also in chapter 2 on ethical obligations, there's a new obligation through the World Medical Association that health professionals must document torture when they see it or suspect it. That didn't exist before, and we have clarified, for example, the conflicting obligations that arise sometimes. People don't want, they want the autonomy not to document because they fear reprisals and so forth. So we've addressed that complicated issue of conflicting obligations. And as James said, that our understanding of the effects and how to document torture, the physical, psychological effects, we've expanded the section on children and lesbian, gay, bisexual, transgender, and intersex persons. And we have these 2 new chapters, the one that I mentioned on implementation, which I think is quite profound because it really pins states down to what they should be doing in order to create the conditions for effective investigation and documentation. And the other one is on investigation of and documentation of torture by clinicians in non-legal settings, as others have said. Rohini, as you mentioned in your case example, introducing this webinar, what clinicians need to know in those non-legal contexts. Also in prevention and monitoring visits. When we originally established the Istanbul Protocol, there was no optional protocol to the UN Convention Against Torture. And since then, we do have OPCAT, as it's abbreviated, and the UN Subcommittee on Prevention of Torture and their national counterparts, so-called national preventive mechanisms that go to places of detention and facilities and so forth where torture may happen unannounced, and they investigate possible torture. So the IP is used in those settings, and we've created guidance in the new edition of the Istanbul Protocol for those settings. So have no fear. These are strengthened guidelines. This is not a new protocol. So I encourage you to download it and read it. And I'll say one more thing about the content of updates. There's a PowerPoint summarizing all of the IP changes that we will share, that will be at least on the PHR website, probably other organizations represented here today, that summarizes the changes and pinpoints the paragraphs, the new paragraphs that deal with the changes, so that people can easily find what's new and different.
Thanks, Vince. Actually, jumping off your point about the new chapter on implementation, one of the audience members had a question that was sort of similar to mine, which is, how do we address states that are either continuing to use torture or evading accountability, or even, as Juliet mentioned in the case of UK, not acknowledging what actually happened in other cases? As we all know, there's many, many states that are still actively torturing their citizens. So how do you think the Istanbul Protocol can work on those issues at that state level?
Is that to me, Rohini?
Sure.
I would encourage others to respond to that. I do think that the implementation guidance that we've provided in the new edition speaks to countries where there's adequate political will and resources and legislative action to criminalize torture and so forth. And so for countries that are bad actors, let's say, where torture is happening with impunity, there's no intention or political will of changing the status quo. Civil society and international actors are critical to document, to make people aware of what's happening, and to bring about change in many different ways, whether that's through international criminal courts and so forth, awareness, legal cases, etc. So civil society is key in any of these institutions. As Şebnem has already talked about the experience in Turkey, it's civil society that is really holding the state at bay, or trying to. And so in other settings where countries are in transition, this happened in the former Soviet Union countries, some of them in Georgia, and I worked in Central Asian countries for a good 8 years or so, where there was an opportunity, a historical opportunity, to really change the sort of institutionalized practice of torture. And that's where our new guidance on implementation can really be used to bring about a sea change in a country.
Thanks, Vince. Juliet, do you want to jump in?
Yeah, I just wanted to add that I think the new additions in the ethics chapter are also very helpful in demonstrating how to remind doctors who may be working in different settings that they have an obligation to put the needs of their patient first and above all else. There was a term, dual obligations, or dual loyalty even, that was used for doctors working, say, in a prison or immigration detention, which implied that they had to divide their ethical considerations between what they owed their employer and what they owed their patient. And we've revised that and updated it to make it very, very clear that you only have an ethical obligation to do your best for your patient, to understand their healthcare needs, to report torture, and to document it effectively. And I think also the new Chapter 7, which is about those healthcare professionals working in other settings who are not necessarily commissioned to write a full medical legal report, but will come across torture survivors. It demonstrates not only their obligations to do their best for those survivors, but also the state's obligation to train all such healthcare professionals working in those settings, that those professionals must be trained in the proper assessment of the torture survivors' needs.
Thanks, Juliet. That's a very good point. Juan?
Well, the eradication of torture is a very, very long path here, but these are steps in the right direction that can be very helpful. Just to give an example, in a country where torture is very, very pervasive and very, very brutal, rising to the level of a human rights crisis, and I'm talking about Mexico. And it happens because even forensic doctors employed by the state deliberately misuse and misquote the Istanbul Protocol. Nevertheless, it has to be noted that the Supreme Court of Mexico has just come out with a model decision that is called a Protocolo de Actuación, that is a protocol of how lower courts have to act, that is very detailed and very supportive of the idea that torture is an international crime and that impunity for torture is completely unacceptable. And in a great way, it benefits from the old Protocol of Istanbul and the new Protocol of Istanbul, because it directs lower courts to respond in appropriate ways to the incidence of torture.
And Şebnem?
Thanks, Rohini. I want to add a few words about this, but I think Juan wants to continue. Maybe I can take the floor afterwards.
No, go ahead.
Okay. Actually, the most important part is we have to keep in mind that torture is practiced by state officials. So the perpetrator should investigate and document effectively. Could it be possible? Of course not. So thanks to Vince, that civil society has the main role here, and particularly the human rights activists, that we keep the state on bay in this sense. And Istanbul Protocol helps a lot. And also, when we say that there is the new edition, yes, the new edition, because we need some disease classifications, for example, which has changed. So we had to include them. For example, World Health Organization's ICD is now 11. When we started, it was 7.
9.
So it has changed, of course. And DSM for the psychological evaluations, assessments has changed to 5, and probably will be a new one. So, again, I want to remind that when we had the trainings in Turkey, for example, with the enforcement of civil society, the state had to organize trainings, and we were involved with those trainings. And the physicians told me an interesting story, that they felt that they are physicians. In this guideline, they feel being a physician, because it is the most strong part of Istanbul Protocol. The ethical basis, the principles is included, and a reminder for all the physicians in that document. And now it has strengthened throughout the World Medical Association's new declarations, statements, resolutions.
And Vince?
I just want to give an example about Mexico that Juan raised. Indeed, Mexico has a serious problem with torture. And there was a period under a previous administration, the Fox administration, where we actually were invited by the Federal Attorney General's office to train the Federal Attorney General office's forensic corps of clinicians. And we did that, and they were enthusiastic and did everything right, so to speak, in terms of establishing laws that it compelled them to use the Istanbul Protocol, used a form that we approved of and so forth. But the administration, after 8 years of doing that implementation work, changed, and they weaponized the Istanbul Protocol such that they would use the absence of evidence or sub-threshold symptoms of PTSD, the diagnosis, to say that torture didn't happen. Then they would prosecute people for making false allegations, quote unquote, against police. And so it's a rather disgusting and unseemly story in Turkey about how they have gone in one direction to try to embrace the Istanbul Protocol and then rejected and weaponized it. It's a serious concern. I'm glad to hear, Juan, that the Supreme Court came out with this decision. I knew that was coming. But the example I want to talk about is how independent clinicians in Mexico have formed a network to analyze the evaluations and the decisions that have been made, the evaluations of forensic doctors in the Federal Attorney General's office, to hold them accountable for not following Istanbul Protocol standards. And so the framework is still there. What we need is the civil society networks of people to continue the analysis and criticism of breaches in practices. And I'm encouraged that that courageous work is continuing in Mexico.
Actually, let me deepen that and ask, so, there's over 180 contributors all over the world. It has sections on the law, on ethics, on medical documentation, on psychological documentation of torture, as well as on implementation and more. I know this call has, hundreds of people on it. And so I wanted to ask, for those on the call, in terms of civil society and those who use it, how do you see this being used for, how do you see young lawyers or medical students or residents, all of these folks really engaging in whatever country they are in continuing torture work? What do they need to know? What should they be working on? Social workers, even. And Juan, do you want to maybe touch on that?
Just briefly, I think one thing that I would recommend is to read the Istanbul Protocol 2022 very carefully, because it has a lot of bibliography, a lot of citations that can enrich the knowledge and also get very good ideas about how to approach a problem in which the detection and determination of torture is an issue. And I think at least, certainly for lawyers, this document is very helpful in breaking the cycle of impunity for torture by putting the burden on courts, prosecutors, public defenders to take seriously the not only the political will to investigate, but also the correct and scientifically proven way in which those investigations have to take place.
Thanks, Juan. I know we're getting a little short on time, so let me ask one more big question and then maybe jump into some of the audience questions as well. So in terms of the international community that, let me see, I'm going to ask this one. So in terms of civil society, which organization, like how do your organizations work on torture activities now? And how do you think the Istanbul Protocol is going to promote or strengthen that work? Whether it's Physicians for Human Rights or the Human Rights Foundation of Turkey, or, Juliet, if it's, medical organizations or the IRCT, like how would these organizations work with the IP and engage with that?
Shall I jump in?
Please.
Yeah. I think that it will continue to be used in all sorts of ways at different levels. So particularly with the new Chapter 7, I think we'll hope to see people using it more as a brief report, not necessarily a complex, comprehensive torture report, but a short announcement, if you like, that there are serious concerns that this person is a victim of torture. And those reports can be used to help somebody, for example, get released from immigration detention when they don't necessarily need to be detained, and can help people access better health care. We will obviously still be making these comprehensive reports for asylum seekers. But one of the things as well, I think that using the guidance of the Istanbul Protocol to have this structured format is that you can collect and compile aggregated anonymized data on larger groups of torture survivors, perhaps from the same country or region or similar methods of torture. And this can be used very powerfully at higher levels. Freedom from torture, we did that successfully at the UN Human Rights Council, presenting evidence on the torture of Tamils in Sri Lanka, of Iranians at election times, for example. And yet it's such a flexible document, you can also use it all the way up to the International Criminal Court for individual cases. So that flexibility of approach is, I think, one of its great strengths.
Vince, do you want to jump in?
Yes, briefly. Yeah, I do think the lesson of the Istanbul Protocol is that we can be very powerful. We can empower ourselves when we work together, develop consensus and work together. And there is this group of 180 plus people in 51 countries that can act together in concert to do certain things. I mean, with the war in Ukraine, we are now doing capacity building for assessments of allegations of torture and other forms of violence. And I do think that we need to consider, we're in the process of considering what are meaningful next steps. I would like personally to see the UN to make assessments of Istanbul Protocol implementation in countries part of the periodic review process. And the UN Committee Against Torture, CAT, and others like the Special Rapporteur on Torture have used the Istanbul Protocol to make recommendations to countries and so forth. That's very helpful to coordinate the kinds of actions for documentation and implementation and so forth that needs to be expanded and so forth. So I think the answer really is working together and developing consensus and moving the group as a whole.
And James?
Yeah, I guess for the IRCT, as Julia mentioned a little bit, we are trying to find ways to make documentation simpler and more accessible, right? In some ways, by making or adding much more guidance into the new edition of the Istanbul Protocol, what we've actually tried to do is to be clearer and simplify the process. Like Vincent mentioned, although the Istanbul Protocol proposes something very comprehensive, it follows very simple principles. And so we're trying to develop tools for then others, even human rights activists like Şebnem mentioned, even protesters and others to be able to do the basic steps of documentation, right? To grow our base of understanding of individuals who know how to collect evidence and to document and try to prove torture and ill treatment happening in their own specific context. So for us, we're always trying to find new means and methods, right? We've launched illustrations on Instagram even. We're trying to develop online trainings. We're constantly developing templates and tools, not only for professionals to use, but even for individuals themselves in different contexts to sort of expand knowledge, right? And make it common knowledge, right? And to build common understanding so that, just society members, individual citizens who are interested in human rights work. Because I think in the Philippines, for example, we see that without this kind of consistent push towards documentation, understanding, right? Now we have, for example, the son of a dictator who has now revised history and been reelected. So we really need to, human rights is changing, and people who are getting involved are younger and younger, and we're trying to find these methods at least. It's a little bit difficult, I have to be honest, but we're trying.
Thanks, James. And Şebnem?
Thanks, James. Yes, we try, and our resilience is an example, I think. For Human Rights Foundation, I wanted to add that it is also a way of assessing the needs of treatment for torture survivors. Very helpful for the psychological assessment, for example, helps us to just decide on which type of psychotherapy would be helpful for the case, and also the social support would be in a certain way according to the assessments based on Istanbul Protocol guidelines. So it doesn't only help to document torture, but also just shows us the way how to treat these people, how to support them, or particularly the social support is very helpful for these people so that we can have assessments for that purposes. The Human Rights Foundation of Turkey is not only documenting, of course, the documentation is a very important part of our work, but rehabilitation is the main work for the Human Rights Foundation. So I wanted to tell that it is not only documentation, but it helps us a lot.
That's right. And I think Vince was the first one who said to me that all physical torture has psychological impacts and all psychological torture has physical impacts. And really integrating those, understanding that holistically and helping those survivors in that way is really the most important piece of the work. I'm going to ask Juan one question. How do you think that Istanbul Protocol work factored into your new work with the Mendes principles? I don't know if you like that they're called that, on non-coercive interviews of persons deprived of their liberty. And can you share a little bit about that?
Yes, well, thanks. I don't call it the Mendes principles because my mother would never forgive me for taking credit for the work of so many brilliant colleagues. It's the principles on effective interviewing in investigation and other information gathering processes. And I know that's a handful, and that probably explains why some of my friends wanted to call it the Mendes principles. But I do think that it goes hand in hand with the Istanbul Protocol in the sense that it addresses itself to a certain category of actors in the problems of torture and ill treatment that are the police interrogators or the law enforcement interrogators. And in addition to reaffirming the very absolute prohibitions on any form of mistreatment in interrogation, the principles also offer an alternative that is not only more humane and more ethical and more professional, but it's also much more effective in finding out the truth, which in the end is the real purpose of all kinds of investigations. So we aspire for the principles on effective interviewing to reach the level of weight and credibility and rigorous analysis that the Istanbul Protocol already enjoys. And I mean both the 1999 protocol and now the 2022 protocol. But for now, we're very encouraged by the reception on those principles, but we're still working on getting some forms of international recognition for them by way of United Nations resolutions of some sort or another, which I think will happen relatively soon, or at least I hope so. And in the meantime, I think this document plus the Istanbul Protocol plus the Minnesota Protocol on how to investigate extrajudicial executions plus the Nelson Mandela rules on minimum standards for the treatment of people, of prisoners. All of them constitute a kind of a normative framework that provides us with instruments and weapons to fight against torture and eventually to eradicate it.
Thanks, Juan. I'm going to jump to a couple of the audience questions, and I know there's more than 30 of them, so I apologize we won't get to all of them, but I hope this will engage you, and we'll answer some key ones, and then I'll be a professor here and say, if you read the IP, I'm sure you'll get more answers than in this short call. One of the participants asked about solitary confinement. And the Mandela rules suggest that solitary confinement really shouldn't be used over 15 days or so, and that it is a form of torture. And I was wondering if one of you wanted to speak a little bit on what the IP might say about that and your experiences with people who've been in solitary.
Well, solitary confinement is a form, at least prolonged or indefinite solitary confinement, or solitary confinement used for people under 18 years of age, or for pregnant women or expectant women, breastfeeding women, are definitely psychological torture. There's no question about them. The Mandela rules establish a regulation for the legitimate uses of some forms of isolation, because there are legitimate uses as long as they're last resort, they're short term, they're based on some kind of due process guarantees that you don't do this just out of revenge or vindictiveness or selectivity. It's the pain and suffering of a mental nature that is directly deliberately inflicted that definitely qualifies as torture. And it has, as Vince said at the beginning, the definition of torture has always included mental torture as a form of torture.
One of the audience members, Juliet, mentioned the 2 to 4 page assessments that you described for longer full IP evaluations as an issue for both asylum and for victims of torture. And she asked, what do we know most matters to adjudicators about the work? Is it clear what's effective and what's necessary?
Thank you. That's a big question, and it really depends on the particular jurisdiction that you're working in. Like I said, those very short reports were what we did a long time ago, and we were sort of driven to writing more and more complex reports, not just because we were learning more about the impact of torture, and like you said in your initial patient anecdote, Rohini, when you know what to look for, you find it. Mm-hmm. But also we were finding that when the political weather turns against you and decision makers harden their hearts, then they will treat medical evidence in a more hostile way, and they will dismiss reports which they don't feel are substantial enough or that they can undermine in some way. So that led to us writing more, demonstrating more of our reasoning. It's not ideal because one of the consequences of this is that for each individual clinician, it takes longer. It takes longer to make the assessment, longer and still to draft the report. And all of this has kind of escalated over the years I've been doing this. And that can lead clinicians to burn out, to not have enough time to do the work, to stop doing it. And we need to train more and more people. So how do we turn that around? Like I say, it is a problem. It's a bit chicken and egg, and you have to work with the jurisdiction you're in. It's no good unilaterally saying, well, I think 2 pages is enough if the decision maker, the judge, is going to dismiss that. But we can work to educate both sides about what is a good enough report and what is really essential to include in a report.
And Vince, did you want to add?
Yes, that Juliet's so right that it really depends on where you are and what the expectations are and so forth, and the need to continually improve one's documentation's efforts, whether required to or not. And I would steer people who are trying to, economize their time and so forth to Annex 1, the principles, Istanbul Protocol principles, which give the bare bones of what is required in a clinical evaluation. That has not changed, as I've said before. And so those elements are essential. I would say that a good medical legal examination evaluation, whether it's for asylum purposes or other, really should be detailed and include all of the components, including a thorough psychological evaluation. And at least people need to be moving in that direction if they're not there already.
Thanks, Vince. I know a lot of the time when we speak about torture and the formal definition obviously includes state actors, but one of the audience members asked about using it for clinically for other trauma, for domestic violence or police violence, and how that would be done, and if you would call that torture, or how you would use the IP in those cases if you were seeing patients with that kind of trauma. Şebnem.
Actually, I want to remind that there are guidelines for such kind of cases. For example, domestic violence or rape cases. World Health Organization have had several guidelines based on these kind of topics. But Istanbul Protocol is a guideline for injured people's medical examination also. So any kind of injuries might be evaluated, and the assessments can be based on Istanbul Protocol as a guideline. But the other guidelines might also be used, the specific guidelines might also be used. So I wanted to remind them.
Thanks, Şebnem. I'll add to that and say I've used the IP for all of these cases as a physician. I've learned about where defensive wounds would be, or why someone would be hit in a certain way. And as Vince mentioned earlier, we've also used these guidelines for research, for population-based studies to understand what happened to groups that have experienced crimes against humanity. We did a paper on that among the Rohingya refugees in 2017, for example. Okay, here's a hard one. Do all countries accept the Istanbul Protocol? And what determines this acceptance?
Well, the Istanbul Protocol is not a treaty, so it is not subject to acceptance or rejection by any state. It's a very well-regarded and convincing element of what sometimes in international law is called non-binding international norms. Non-binding international norms can over time become binding as a matter of customary international law. That's another question. I mean, parts of the Istanbul Protocol may well have become customary international law by now, especially since so many human rights courts around the world, when they say that the state is responsible for not having investigated properly, they do cite the Istanbul Protocol. They cite it as the professional gold standard of how investigations should happen from a medical or psychological perspective. So the states are not free to adopt or not adopt the Istanbul Protocol. What happens is that you have to persuade courts that this is a proper standard, and that obviously is on a case-by-case basis and even on a court-by-court basis. But that's why I think the new version of the Istanbul Protocol is going to go a long way in making courts be more responsive to problems of torture.
Thanks, Juan. I know we have about 10 or 12 minutes left, so I wanted to jump into a bit of a lightning round. I warned the panelists about this, and I just want to spend a minute or two with each of you telling us what speaks most to you about the update, the work, the protocol, and the anti-torture movement. Really, what is the so what here? And just really quickly, so that we can remember, what do you want the audience to take away from this conversation and remember about the IP? And I'll call on folks. So maybe James, do you want to go first?
I gladly will, I guess. Sure. I think the new protocol, what stands out is really just the amount of guidance, right? The amount of understanding. It really has gone from a document on presenting a protocol on how to document to a consensus document on what torture is, how it affects people, how it affects the way they engage with judicial proceedings, right? How we have to rehabilitate, right? And so it's really shifted character in some ways, still an international standard, but one that really provides almost a comprehensive understanding, at least the most comprehensive we have now, that's globally applicable. And that becomes very powerful, because then we can really, it speaks more clearly to people all around the world, because that's where we work. So for me, that's really the most important.
Thanks, James. And how about you, Juliet?
Yeah, so I'm going to take it more on the individual level, that for my work and for those of clinicians that I train, I think that it's going to be a big help in understanding your role in identification of torture victims and documentation of their torture. And the whole purpose of that being to fulfill your obligations ethically, to help survivors access the healthcare they need, the rehabilitation to which they have a right, and to bring accountability to the perpetrators. And that's it for me.
Thanks, Juliet. How about you, Şebnem?
Yeah, actually, when Juliet and James talked, I just thought that with this competitive world, the world is getting more competitive every year. Istanbul Protocol just reminds us the happiness of working in a team, in a solidarity. We need each other. It is so crucial to have the psychologists, the lawyers, and for the lawyers, we have professionals, and all of us need the human rights activists to use this protocol and force the states to use the protocol.
Beautifully said. And how about you, Juan?
Well, it's going to be a great tool in breaking the cycle of impunity and discouraging future acts of torture by security and law enforcement forces. But in addition to that, it's very helpful in determining the proper applicability of the rule of exclusion of evidence obtained under torture, and therefore will provide for better and more fair trials, especially in the criminal justice area. And beyond that, it's going to help in refugee and asylum law, because it is going to be easier to demonstrate that someone should not be sent to a jurisdiction where he or she faces the risk of torture. And finally, I think it's going to help in prevention for all of those very same reasons, including the possibility of reparations and rehabilitation, like Juliet said. I think in the long run, we're going to have to attack torture in all of these different ways in which it happens. And the Istanbul Protocol is going to be a great tool in that direction.
And Vince, let me end with you.
It's hard to add anything to the comments of my brilliant friends, but I'm going to expand this a little bit to the big picture. To me, the Istanbul Protocol carries with it the lesson of power, and it's all about human rights. I mean, human rights, after all, are social claims that were made after the horrors of the Second World War, right? That we don't want torture, slavery, and all kinds of freedoms. We want protections for freedoms. And the Istanbul Protocol, as I started to say, but didn't completely finish, why this idea came up. You know, in 1996, I had started the course, Rohini, that you teach now, the Health and Human Rights course at University of California, Berkeley. And that was the time of women's human rights just getting started. And I learned a very important lesson at that time, attending conferences on women's human rights in Vienna, that these are social claims. You have to empower yourself. You have to articulate what's important to maintain the freedoms that are so important to human existence. And so working together in these large groups and developing consensus, we've done that. And as Juan just said, we have effectively created the international customary law for the standing of the Istanbul Protocol. It's time now to use that empowered status to make it effective everywhere, whether that's international human rights courts and organizations, national settings, in our clinical work and so forth. We have that power. Let's use it wisely. Let's use it together and celebrate the success that we've had over some time.
Thank you so much, Vince. I'll end with those words and just say it's been a privilege to work with all of you over the past 6 years, to see this Istanbul Protocol come to fruition. And all of you on the audience can download it online. It is in English. It will be available soon, eventually, in the UN languages as well. And onwards. Thank you, everyone.
Thank you.
Thank you.
Thanks, Rohini. Thank you, everyone, for
Thanks
participating.
a lot to PHR.
Thanks, everyone. Great to see you guys.
colleagues.